This podcast represents a brief history of the law relating to the issues raised. This should not be relied on as a substitute for professional advice. Specific legal advice should always be sought in relation to any particular circumstances, and no liability will be accepted for any losses incurred as a result of reliance on this podcast by those relying solely on this podcast. Welcome now to Hicksons Health Hour, the podcast series that explores a variety of current legal health topics. Throughout each episode, hear from different members of our health team with expertise in the area.
On today's episode, we will discuss the Monash IVF Group Victoria class action, stemming from allegations it used inaccurate genetic testing and destroyed potentially viable embryos. Monash IVF, a prominent fertility service provider, has recently agreed to a $56 million settlement of a class action brought in the Supreme Court of Victoria against them by more than 700 former patients. The class action sought compensation for financial loss and psychiatric injury for individuals who received genetic testing on their live embryos between May 2019 and October 2020. I'm joined today by Bridget Shields, an associate in the health team here at Hicksons, who will break down the legal aspects of the Monash IVF case and what it means for the future of reproductive healthcare. Welcome, Bridget.
Thanks, Meesha.
So to kick things off, could you walk us through what led to this class action?
Absolutely. The class action was brought by plaintiffs and group members who alleged that they suffered harm as a result of cell-free, non-invasive pre-implantation genetic testing of their live embryos between May 2019 and October 2020. Unlike an embryo biopsy, this testing is non-invasive and is thought to have a lower risk of damaging the embryo because it uses DNA from the culture media that the embryos grow in the first few days of the IVF procedure.
So what does it test for?
The test shows the number of chromosomes in the material taken from the embryo culture medium. It allows for detection of conditions associated with aneuploidy, which is additional or missing chromosomes like Down syndrome or Turner syndrome. Embryos with chromosome alterations have a lower probability of viability for a pregnancy and might not be considered suitable for transfer.
And what was the problem with the non-invasive genetic testing?
So non-invasive PGT still has a place and is not problematic in and of itself. The issue here was that the defendants did not warn patients of the risk that this particular genetic testing might yield false positive results for aneuploidy. So potentially viable embryos were deemed unsuitable for transfer and discarded. This is thought to have impacted over 1,000 patients who underwent treatment, and there were 700 patients who ended up joining the class action.
Okay, so the testing yielded false positives. I can see how that might be problematic.
Yeah. For example, one of the lead plaintiffs was informed that her last embryo, which had undergone the non-invasive PGT testing, had an abnormal test result, having been identified as aneuploidy. Since the embryo was classified as abnormal, it was discarded. She, along with other patients, were later notified via email that non-invasive PGT testing showed that the proportion of embryos classified as abnormal was higher than what was observed in the clinical trial and that testing had been suspended.
It's a difficult situation. What was the standard practice at the time?
At the time, the defendants were conducting the only fertility treatment program in the world that used the genetic testing as the sole basis to discard live embryos. So the plaintiffs say that further research was needed to evaluate its potential for clinical application. Essentially, the plaintiffs say that it should not have been used as the sole basis for determining embryo viability. The statement of claim states that test results were appropriate for prioritising embryos classified as euploid for transfer, but not as a basis to discard embryos.
So what were the core claims made by the plaintiffs?
The claim really centred around the lack of warning about the risk of false positives for the genetic testing, meaning that patients did not receive proper informed consent for the testing to occur. It was also suggested that ReproMed, which conducted clinical trials relating to the non-invasive PGT testing, doctored the results of a clinical trial, forged patient signatures on consent forms, and burnt paper evidence relating to testing of embryos deemed as abnormal. In this case, Monash IVF had a duty to obtain informed consent from their patients and take all adequate steps to safeguard their embryos, which, as one can imagine, is critical to those hoping to start or grow their families. So this case hinged on whether Monash IVF had breached this duty of care and whether that breach could be linked to the emotional and psychological consequences for the patients.
So, in simple terms, this case was about whether the clinic met its legal obligation to ensure the proper handling of these embryos and the information given to patients about what this testing meant. So, what is the process for seeking compensation when this duty is breached?
This matter was perfect for a class action because it affected hundreds of patients and they could be consolidated into a single lawsuit. Any patient who received the cell-free, non-invasive PGT testing of their embryos between May 2019 and October 2020 and had their embryos destroyed, discarded, or not implanted as a result of that testing indicating the embryos were positive for aneuploidy were eligible to participate in the class action. The group members had to show that they suffered a psychiatric injury, including those suffered as a result of the increased likelihood of the needless destruction of or failure to transfer an embryo incorrectly classified as aneuploidy, and or financial loss from undergoing the testing and having an embryo destroyed or not transferred as a result of the testing. And this also included spouses and partners of the patients.
So this class action settled in August of this year. What does that mean for the parties involved?
First, it's worth noting that the settlement doesn't reflect an admission of guilt. In fact, Monash IVF has denied the allegations of negligence and mishandling. However, with any case involving a public health organisation, they need to weigh up the legal, reputational and financial risks of a public trial. It also means that the plaintiffs don't have to go through the trauma of giving evidence at a hearing. And the settlement means that the legal and medical issues won't be fleshed out at a public trial, which was originally listed for hearing in October 2024.
So how is settlement typically structured in cases like this?
So the settlement approval application hasn't been heard by the Victorian Supreme Court at the time of recording, but the $40 million will be distributed amongst all 700 and something group members, as well as anything left over from the $16 million for costs once the plaintiff's legal costs have been paid. The exact amount each person may get could vary based on their individual circumstances, and the two lead plaintiffs will also get an extra $50,000 for the personal burden of being those lead plaintiffs.
I imagine a case of this scale will also have some broader impacts beyond the monetary payout. So how does this settlement affect the legal landscape for reproductive healthcare in Australia? And do you think it'll have a broader implication for the industry?
Absolutely. It's not just about the money, it also drives change. First and foremost, the settlement serves as a warning to other fertility clinics and healthcare providers about the importance of maintaining rigorous standards in handling sensitive medical materials, such as embryos, and advertising the success of novel testing procedures. We could also see an increased focus on regulation and oversight in the IVF industry as a result. Fertility clinics may face stricter scrutiny about how they test and handle embryos, as well as more robust informed consent processes and patient communication protocols. We could see new laws and regulations designed to better protect patients in these highly sensitive and expensive medical procedures.
So before we wrap up, how would you summarise the main takeaway for healthcare providers?
Well, the fertility industry is particularly fraught as they hold the responsibility of managing people's reproduction, which is one of the most intimate and important decisions of people's lives. When issues like this occur, it undermines the trust patients place in clinics. But I think the lesson here can be applied more broadly for all healthcare providers and researchers. This case really shows that new tests, procedures, and drugs need to be rigorously tested and evidence-based before they're presented to the public, and that patients need to be given all information and caveats to make an informed decision about their treatment options.
Thanks again to Bridget and to our listeners for joining us on Hicksons Health Hour. Stay tuned for our next episode, where we continue exploring the intricate interplay between medicine, law, and society.